Little while. Today is a really special episode because I have my very good friend Ron Chapman II of the Chapman Law Group on. We have just come out of last week another federal criminal trial in the Eastern District of Kentucky, where the trial was held in London, Kentucky, which is about an hour and 20 minutes outside of Lexington. I'm going to let Ron lay the foundation of the case, but what I will tell you is this is the fifth case in 12 months that the uh, defendant was found not guilty, meaning full acquittal at trial. And that's pretty unheard of for one attorney. So, um, as always, I want to welcome my good friend Ron Chapman to the program. Ron, it's great to see you. I'm telling you, I tell people this all the time. You are the Fred Astaire of the courtroom. Um, but you really are. I mean, and I tell people this all the time. You don't need to hear this from me, but I tell people this all the time. Your mastery of handling witnesses and setting them up to get the maximum out of them on direct examination creates such an insurmountable hill for a prosecutor to climb and get over that it's absolutely amazing to me. And I know there's a lot of great defense attorneys, a lot of great criminal defense attorneys out there, but in all sincerity, I mean, you are in the top 1% of 1%. And I tell people all the time, if I were the person who were being accused of something, um, there would be no hesitation on my part. Ron Chapman would be the only call that I ever made to represent me. And
Wow.
I don't want to offend any of my other friends who are criminal defense attorneys because I have nothing but mad respect for them and I know they're wonderful. But I have done the majority of my casework with you over the last year, or I've done the majority of my casework in criminal trials with you,
Yep.
and there's just no room for me to vary from that. So, with that said, welcome Fred to the podcast. It's great to see you, and it's great to spend time with you. And I know the listeners can't wait to hear all about this case.
Well, I love the Fred Astaire analogy because my late grandfather was a dancer, and he had the opportunity to dance with Fred Astaire. It's on video somewhere out there, but that was his 15 minutes of fame. He may have had a few other minutes too, but I love that you mentioned Fred and Sean. With respect to your kind comments, I'm kind of reminded of that movie Jerry Maguire, back from the '90s, where
Oh
Cuba
yeah.
doesn't want to go on that show because he knows the guy's going to make him cry, and then he finally breaks down. Those words mean a lot to me. First, because you're a good friend. Second, because you are commanding in this industry in terms of your ability to know the issues and speak as a credible expert. And so that compliment means more to me coming from you than from just about anybody else. So let's jump in and break down the case. You talked about creating an insurmountable hill. You've captured exactly what we do here and the reason why we've gotten those acquittals, right? And first, let me preface all of this by saying that hill isn't just created by my words in the courtroom. That's the visible stuff. That's some of the tricks that we play when we're on the battlefield and the things that we do when we're actually fighting. But there's a whole logistical effort behind us, which includes you and the rest of my team, which starts to create that hill from pre-indictment investigation all the way until we finally get in the courtroom and get the ability to speak on behalf of a doctor. So what we do in trial and pre-trial is we try to create that hill for the government. Now, let's start with, generally speaking, the issues. The federal government has decided that they want to start prosecuting providers for things that used to be or should be purely administrative in nature. Improper coding of evaluation and management, issues with the way that a drug is being prescribed. What they've decided to do with these indictments is take what should be civil issues or administrative issues and turn them into a federal criminal case. And that's just not the right thing to do from a starting point. So we know that unlike your traditional murder case or larceny case or embezzlement case, where the conduct is clearly wrong and clearly criminal, the government is already starting in a bad place here because they're trying to convince a jury of something that is very complicated to understand, doesn't really seem to be that serious anyway, even if the violation is proven, and is very clearly hyper technical. And that was our theme for the Kusa case. The government is taking a hyper technical view that it doesn't completely understand. In closing, I got the most head nods with this comment. The government doesn't even understand evaluation and management billing and coding. And here's why. And I showed them a code that they alleged that was improper, that their expert didn't believe was improper, that you believed was completely proper. And I said, if the government, who had years to investigate this case, brought an indictment, brought it through court, brought it to trial, brought it to you, ladies and gentlemen of the jury, you would think that they would understand whether or not this was a valid code or an invalid code. And you would think that they would figure that out before they ever took your time out of your day in your life to determine this. And, tons of head nodding. So let's start with Dr. Kusa. He's Syrian, came to the United States about 30 years ago. He was on one of those programs from back in the day where if you went and served in an underserved area, you'd have a little easier time getting licensed and coming to the United States. Can't remember the name of it, but he started in Paintsville, Kentucky. Paintsville, Kentucky is small mining community, lots of primary care issues, very close to West Virginia. So you've got, kind of the Appalachian Mountain region, relatively closed or close-knit society down there. And he was the family doctor in town. Went to the hospital, rounded at the hospital, saw patients, saw tons of people. No issues during this man's entire career. Huge fact for the trial. The government is putting somebody in a federal courtroom who doesn't have a track record or a history of doing anything wrong. They decide to launch an undercover operation in the middle of COVID-19. So we're talking June 2020, April 2021 is when the undercover operation started. And this was a pivotal moment in the case, Sean. The undercover that they used was a task force officer from the DEA. Task force officers aren't DEA agents, they're task force officers. They're cops who just get a DEA, set of credentials, but they don't really have the knowledge of DEA. And on cross-examination, this guy completely broke down. When I showed him, and all your providers who are listening out there may recall this flow chart, the flow chart that the DEA put out that discussed what was a legitimate medical purpose during COVID-19. He didn't review it before he started his undercover investigation. He didn't review it during his undercover investigation. He didn't review it before he went on the witness stand to testify about a provider allegedly dealing drugs, which set up the closing argument statement that I made. You would think that if these policies and procedures were clear for doctors so that they knew the limits of their conduct, the DEA would have known that they existed beforehand. And again, we got a lot of nods.
It's just mind-boggling to me, though, Ron, that, these individuals don't stop to think for one moment about the reputational damage, the destruction to family life, the loss of income, the loss of their health that they're creating for these individuals, that they are making these baseless, factless allegations of impropriety and nefarious behavior against these individuals. And, I never met Dr. Kusa prior to the trial.
Yeah.
And that's how it's been in every single case that I've worked with you. I've never met them because I don't want to be biased, right? I don't want to go into the case feeling like, God, man, what a great human being. What a wonderful person. To me, prior to a case, they are just another case, right? And I know that sounds kind of cold, but I need to be without passion, without prejudice, without bias. I want to be able to go in and just speak to the facts, and I want to do my job. But what was so amazing to me was even before the verdict was read for Dr. Kusa, after my testimony, I got a chance to meet him. And from the minute he smiled, and shook my hand, it was like, wow, what a great guy.
Yeah.
And he was just so appreciative, and you could tell his sincerity. You know, he reminded me of Dr. Bothra
Yep.
in a
Yep.
lot of ways, just that good, kind, appreciative, human being.
Yeah.
And, I just remember thinking the whole way back to Lexington and then getting on the plane and flying home, the only thought that I had was there's no way if my direct examination and my cross examination went the way that it had to go the same way for Dr. Murphy. It had to go the same way for the other witnesses. There's no way this case was going any other way than not guilty. I mean, I know that sounds kind of conceited to feel that way, but I did. I walked out of there thinking to myself, there's absolutely no way that this jury is going to convict this guy. And we could talk more about, some of the things, that led to that. But, keep going with, because this story is just a story of an entrapment,
Oh yeah.
of deceit, lies. It's unbelievable to me.
100%, Sean. This looks like pure tyranny to me. I mean, fundamentally speaking, Judge Weir started off one morning during trial, and he was the trial judge in this case. And he sticks very close to the Constitution. Is very proud of his role as a federal judge, which I appreciate. He read a quote about how that the jury trial is something that protects us from tyranny, and that's one of the reasons why I'm proud to be a defense attorney, because it's not necessarily me on behalf of my client. It is me protecting the Constitution to make sure that we have these rights. And I'm just thankful that 12 members were able to sit and fairly view evidence and ultimately determine very quickly that this looks like tyranny. I will say, from a cross-examination perspective, you got it easier than everybody else, and that was strategically. So we pushed you to the end of the day. We knew that we wanted to get you off of the stand pretty quickly. I learned that the person who was cross-examining you was not the person who knew healthcare the best. This was a newer attorney who I don't know had as much experience. And once I found that out, I pushed your direct examination longer to crunch him up against the rest of the day, which made his examination incredibly short, 10, 15 minutes at the most. And, I think that they misunderstood your importance to the case. I think they thought that they could sit down after saying, well, you didn't review the charts. If these charts were false, then your opinion means nothing. Yeah, no, not really. Because one thing that they missed, and this was a very important point in the case, for all the providers out there who have chart errors, I'm with you. Charting is difficult. Doctors don't get paid for the normal things in their chart. They get paid for the abnormal things in their chart. And they thought that documenting a full normal physical examination, because of this charting by exception kind of thing that happens with EMRs, they thought that would have been a lie to the insurance companies. No, because sure, a false diagnosis code put in there may have an impact because it's raising the level under the post 2021 guidelines, but normal physical examinations, unless you're actually certifying that you went through this process with the patient and spent that much time to do the physical examination, we're looking at problem areas, Sean. I know that's oversimplifying something that is very complicated for you, but that's
No, but it's a great point. I mean, that's spot on. That's a great point. And they completely missed the whole purpose of it.
They missed it. So I stood up in closing, and remember, cases are about closing. You don't always have to get your point out through the witness. You can get them there, and then take them to the water, and then let them drink at closing, right? And so I can stand up in closing and say, government for the whole trial thought that these entries in charts which showed normal physical examinations was somehow smoking gun against Dr. Kuza as if he did anything wrong. No. Why? Because doctors put in problem areas that are evaluated, and that is what forms the basis of the complexity of the visit under the 2020 guidelines. So Koussis in this small mining town, practicing as a normal physician, going to the hospital, he gets raided after the undercover visits. Virtually no investigation. And this was another big government mistake here. They subpoenaed the records related to 20 some other patients. They requested the records. The only patient in the indictment that was accused to have a controlled substance violation associated with it was the undercover. So already we kind of have this baked in entrapment argument. Entrapment is a sticky thing because entrapment means you committed a crime, but the government led you to commit a crime. This isn't entrapment because our argument is that it was not a crime in the first place. So I use that word loosely. But we already have this argument at the very beginning of trial. Was Dr. Kusa tricked by a undercover, or was he a bad doctor and the undercover showed that through video evidence? And I said the best way to determine that is for the government to have put on any one of these other 20 patients whose charts they subpoenaed, have an expert review any of these other 20 charts, and find me one single patient other than a law enforcement officer who was very tricky that Dr. Kusa unlawfully prescribed to, and they've got their case. Well, they didn't do that. They didn't feel that was necessary. They just didn't do enough there. So, the pretrial workup in this case was relatively minor. This wasn't the biggest case, not the most severe case. This wasn't a Bothra or a Pompey. We had some prescriptions to a single undercover. We had billing for evaluation and management codes to that undercover, and we had EKGs. The thing that won the day on the EKGs, Sean, is that we know what you have to do. Your doctors know what you have to do for an EKG. You put the patient on the table, you set up the leads, you got to get that all right 100% of the time. You monitor them, you do it, you review the report, and you chart, your review of the report. That's independent interpretation that's required. And for all of that, you get a whopping $11.83.
I don't even know that's enough to buy a large value meal at Chick-fil-A these days.
No, the prices are going up. And I know this because I had to travel down to Kentucky for a case. And sometimes the only thing that was available that was that Chick-fil-A. So, I stood up this was a fun moment in trial. The government's expert spent about an hour talking about EKGs. They thought that was really important. So in cross-examination of the government expert, one of my first lines was, "Hey, how much you paid an hour, doc?" And he's like, $500. Okay. How long have you been talking about EKGs? He's like, well, about an hour. I said, okay. So we spent about $500 in this trial today talking about EKGs. I said, do you know how much an EKG is reimbursed at? And he said, no, I don't know. So I showed him the claims data, which showed that it was reimbursed at $11.93, I think it was. And I said, you have issues with 9 EKGs. Great. How much total is that? $99, right? With the change added, we're over 100, maybe $110. I don't know. So yeah, actually, I think when you do the math, it's higher than that. So in closing, I was able to argue that the government took all of this time and spent all of this money trying to uncover a scheme by a doctor that required he do all of these things to be able to get an EKG actually performed on a patient. And their whole idea of this grand money-making scheme was that he was overcharging patients $11.93. And I said, who in their right mind would ever create a scheme where the most that you could ever profit for your 30 minutes of work is $11.93? And I think that the EKG counts really sunk the government's ship for them. I think at the end of the day, the jury was like, they have reached so far into this barrel of culpability, that nothing's down there.
Well, and again, it was really interesting, because I think rather than try to cross-examine me on the substance of E&M services, which obviously he would have been outmatched.
Yeah.
His questions were, how much were you paid on this case?
Yep.
And how many hours did you work on it? And, obviously, I don't know anything about how much I get paid because that's done through an accounting department. And that's an honest answer. If you ask me on any client, how much have I charged them? I'm going to tell you, I don't have a clue.
Yep.
I literally jot down the hours and what specifically I did on each project that I work on. Excuse me. It goes to my team in accounting and they bill for it. I don't know how much gets billed for. I couldn't even tell you.
Yep.
But then he said to me, well, how many hours did you spend on this case? And I said, I don't know, not many. And, he said 20, and I said, "Yeah, maybe 20." And when I got back and I asked, Lori how many hours did I actually spend on the case, she said, "Between you and Paul, about
Yeah.
20 hours." And I remember he was like, "Why did you spend so few hours on it?" And my response was, "Because this was such a straightforward case. We're talking about 2 patient charts." I
Yeah.
mean,
Yeah.
it was so straightforward. There was nothing to do. Why am I going My motto has always been, "Just because you can
Mm.
doesn't mean you should," right?
Yeah.
I'm not gonna take advantage because I know that
Yeah.
this is a criminal trial. I stick to every case the same way. It's whatever time it takes to get through it, and I know I can go through something in half the time that it takes a lot of other folks, 20 hours to do something that takes me 10 hours. But the government once again went down this rabbit hole of time.
Yep. Yep. So let me jump in here, Sean, because
Yeah, please.
this is exactly the problem with these cases. The Bothra case, the Pompey case, the Kusa case, the Sachi case. The government is trying to learn during trial, and they can't keep up because we're already there. Now, some people indicted for these types of offenses go with your normal criminal defense attorney who's never done healthcare before. You can't do that because this stuff is so complicated. You and I have worked together for so long. I have an LLM in healthcare, which was 2 years of work related to knowing these concepts. You have an infinite amount of experience, more so than anybody in the country, with a team like you and I, plus the other experts that we have available, Mike Staples and our other investigators and Dr. Murphy. um, we we are stakeholders in the healthcare industry. Essentially, we know this stuff inside and out, and a prosecution team who doesn't spend every day knowing this could never do enough work in the middle of trial to be able to understand these concepts. So they indict a case under a time theory, or they indict a case. In fact, this was originally indicted because the government believed that he shouldn't have billed telemedicine codes as evaluation and management codes. That's why they indicted it. So my whole opening statement on the billing side was devoted to showing that the government authorized telemedicine billing for this. And even if you think they didn't, they paid reimbursement rates that were identical. And so there's no harm, no foul here. They indicted under the wrong theory. During my opening, they realized that they had the wrong theory because I was showing the jury the math on how all this stuff comes down. Then they had to pivot their theory. They started to go with a time based theory because their level of knowledge didn't scratch the surface of the AMA coding manual, period. They didn't go into any of the waivers, they didn't go any further than anything. So you can see them learn through trial and they're already behind. Trials are won by being, and this is a military concept, battles are won the same way. You need to spin up and execute faster than the other person. That's when you're in battle in the Marine Corps, you need to be able to spin up and change your tactics faster than the other. And when you can put the enemy on their heels, and they don't have the ability to understand the situation and to be able to change their tactics to meet the situation, they lose the battle. The government loses the case. When they don't understand what the situation is, they don't understand the rules and the regulations related to healthcare, they don't understand what their witnesses are going to say, they don't understand how to cross examine an expert like you, they're already off. They can't pivot fast enough. But here's the beautiful thing: trials are about credibility. I've always said that. That is written all over my book for those who want to buy it, Unraveling Federal Criminal Investigations. Shameless book plug. Sorry, Sean. But trials are about credibility. And when you start with an invalid theory and you fail to spin up properly, you then start grasping for other theories mid trial to try to hang your hat on. But those haven't been sussed out for credibility. They haven't determined that those theories are credible. And so what they do is they start pursuing all of these different, less credible ideas because their first idea wasn't really worked out in the first place. And the jury sees this happening in real time. They're like, oh, well, they were talking about time and opening, and now they're talking about how busy the waiting room is. Chapman killed the busy waiting room theory. That's not very credible. Now they're going to go for, well, you should have billed this a certain way. Or now they're going to say, in fact, their closing was, um, if you don't agree that all of these claims were invalid on the billing side, then we can at least show you two. That was their claim. We can at least show you two. And I said,
Yeah, we could give you two that are completely bogus and fake. Yeah.
I said in closing, I'll give the government the two. He made mistakes on two. Now, let's assume that that's true. Is that a scheme to defraud a federal healthcare program? And this is important for your folks out there. A scheme, and this was a big part of my closing, requires that the person, create and execute a scheme to defraud a federal health care program or a healthcare program and deprive them of some sort of property by false pretenses, right? So you have to lie and you have to scheme. Mistakes aren't lies and they're not schemes. Mistakes are civil penalties, which is where your testimony is absolutely vital, because you talk about this study where 40% of providers, I may have gotten the percentage wrong, are getting evaluation.
42%.
42% are getting evaluation and management coding wrong. That's not a scheme. And I can stand up and admit that my client is fallible. And I actually defined the word fallible on the closing argument slide. And I said, we can't demand that our doctors be perfect or they get prosecuted. Thankfully the jury bought it. There was a lot of reasons why the government could have won this case, but they just didn't do the work to do that.
Well, one of the things that I always talk about is the fact that, it's called the practice of medicine for a reason. Medicine's an art. It's not an exact science.
Yeah.
And to your point, these doctors are not infallible, right? They're human beings.
Yeah.
They make mistakes. And what is so important, and I wish I know there's several prosecutors that watch my podcast because they send me these little notes here and there on direct message about, man, don't say that. But but it's the truth. And I will say this, listen, these career prosecutors, they're good people, right? They are, trying to protect the, federal programs. They're trying to preserve the trust fund. They're trying to do the right thing, right? They're trying to make sure that people who are bad actors are brought to justice. But they are overreaching. And I think they are overzealous in their prosecutions. At least over the last 5 years, they've become so incredibly overzealous. The investigations are so over aggressive. But one of the things that was really amazing to me, again, is just their lack of understanding for how just the most simple, basic component of medical services, E&M, right?
Yep.
Something every single physician does is an E&M.
Yep.
How can you be so ill-prepared and so ignorant when you've had 2 years to prepare for trial? I just don't get it.
This is a critical point, Sean. The government has the tools at its disposal to properly investigate a provider. We talked about TPE thoroughly. I was about to use a different acronym, but we talked
the targeted, probe, and educate.
Yep, targeted, probe, and educate. We talked about that a little bit, I think maybe during your direct exam, or we at least tried. But the government has these tools available. Here's the problem, and let me go back to your comment about good intended prosecutors. I was a prosecutor once. I know how it is, right? You have this job. You're very happy to have this job. You're representing the United States of America. I got to stand up in court and say the United States this and the United States that, and it feels really good. You have pressure to bring cases. You have pressure to win those cases. And you also, in the U.S. Attorney's Office, once you pursue an indictment, in many offices, you don't have the power to end that process and realize that you've made a mistake. So we have compartmentalized decision-making ability. If I can show a prosecutor that they've made a mistake in a case, they will not dismiss it. The reason why is because that would force that prosecutor to go to their boss, the U.S. attorney, or the criminal chief and say, I made a mistake. It's not something anybody is really willing to do. The authority to prosecute and end a prosecution should live and breathe with the individual prosecutor who is going into court. Severing that has caused so many problems in our justice system because people need to be willing to admit that they made a mistake. When I, as a defense counsel, share information that a client is innocent or they've pursued this the wrong way, I should be able to have that message resonate with the individual decision maker and then find an off ramp. Unfortunately, that off ramp is not available to the prosecutor, and I feel for them in that regard. So, kind of going back to how these cases are prosecuted and why, we also have this compartmentalized nature of civil versus criminal. There are some rules that prevent the government from using criminal to coerce a civil settlement. The government's very protective of that, and I understand that. But civil off ramps aren't available. In that LinkedIn post, I kind of sent out a little bit of a message to prosecutors. Here are the few things that have caused these cases to be defense victories. And the first is civil remedies exist for a reason. We have Medicare, Medicaid, we have the MACs, and we have every other contractor available to look into these issues and rectify them without criminal punishment. That process works. There's some flaws, but it works, it's available, and that should be pursued. A provider should only be prosecuted when those efforts have failed. That's why targeted probe and educate exists, because in order to prove knowledge and a scheme, the education must have been unsuccessful. You need to advise the person that what they're doing is wrong, attempt to educate them about the complexity of these processes, and if they continue to do the wrong thing, that conduct is fraudulent. I have prosecutors stand up when I bring up TPE. They stand up and they say, we're not required to educate. We're not required to do any of this stuff. That is a process that only applies to people who commit billing errors. These aren't billing errors. This is fraud. And the fundamental flaw with that argument is that they have determined it was fraud before ever doing the math to show that the conduct was actually fraud in the first place. That is tail wagging dog stuff all day long.
Oh, absolutely.
And that's the reason why the government has lost 5 of these cases in the last year. We've got the Reyes victory that didn't even make it to trial, right? We've got Saatchi, 2 drug distribution death cases that were dismissed by a judge mid-trial in an absolutely incredible victory there. Pompey, Bothra, 2 large, the Bothra case was a $450 million healthcare fraud case, Sean. And that's the critical issue.
Huge.
Yeah, that's the
critical. It is. Here's the thing, and I always hate to go this route, but in a criminal case, if a defendant is found not guilty, they do have a recourse of action against prosecutors for prosecutorial misconduct.
Yeah.
And I know a lot of providers, they're just grateful to be done with the process, right? But at some point, someone has to stand up and say, these prosecutors who are unwilling to do the proper legwork, to retain the proper experts, to do what's right for an American citizen who's being accused of crimes that could essentially end their professional career, cause strife in their personal, lives with loved ones. I mean, think about how many doctors have gone through divorce, after being accused of, fraud, waste, or abuse.
Yep.
The forfeitures that are taken from them, the expenses of legal counsel, consultants, experts, etc. At some point, somebody needs to stand up and take a Mike Tyson swing at some of these prosecutors who don't want to admit they made a mistake and they want to press the issue. I mean, I know it's a tough battle, but there are remedies that exist for those who are found not guilty. Why are we not seeing more providers taking that Tyson haymaker towards somebody who brought them before a jury?
That's a great question. There's an act, an amendment to an act called the Hyde Amendment. And the Hyde Amendment says that when you've been falsely prosecuted or the government has taken a position that is clearly, I think the words are vexatious, frivolous, that sort of thing, that you can essentially file a claim and get attorney's fees and some expenses as a result of the government's position. I filed a Hyde motion in one of the victories that we've talked about before. The reason why is because I think that there were some egregious aspects to that case, which got us there. Specifically, the Bothra case. I think there were some huge issues there with respect to government conduct. The problem with Hyde is that you have to file the claim with the federal district judge, and a lot of judges don't want to grant those claims, and the burden is incredibly high. You almost have to show intentional malice by the prosecution in order to overcome a burden. And with these very complex regulatory issues, it's much easier for a judge to say, I'm not going to grant this because this could have gone either way. They just happened to win. I would need to find, I think that Hyde shouldn't be this way. I think it should be interpreted as if you win at a jury trial and you can show that this position shouldn't have been taken in the first place, you should get your fees back. But I'm probably only going to file a Hyde claim in the future where I'm dealing with hidden evidence, some sort of very clear legal violation on behalf of a provider. That being said, we're a system of laws, and Congress should make it easier for defendants to make themselves whole again after this. As you were talking, I was just thinking about a couple of other clients that had gone through this. And I don't want to get too personal into their stories, but I will tell you that out of all of the people that we've gotten acquitted over the last 12 months, the only one who is sitting in a doctor's office right now practicing medicine today as we speak is Dr. Kusa. The only one. That's sad, right? We have 4 other people that were completely exonerated, but as a result of the dismantling of these people and their lives and their psyche and their credentials and the stigma that's still associated with the fact that a press release was put out to all of your colleagues saying that you're a monster and a drug dealer, that has a very real and lasting impact. One strategy that we're going to employ that came from a colleague of mine, it was unsolicited. He sent me some information about this, and I really appreciate it. Was that you can actually go and get these press releases revised, the original press release the government put out, and have them take it down. And there's some precedent for doing that. So that's something that we're going to do for these past victories and future victories. And then obviously we try to put out a little bit of press ourselves to show that this person was exonerated. A podcast like this where we talk about the issues is also.
And I've written an article that, I wanted to wait for this podcast to be pushed out, which will, which is obviously going to be, today, the 26th of July. Real quick, before we wrap up on our podcast and the Kusa trial, I for me, I try to be a creature of habit, right? And people always ask me, and especially other attorneys, they're like, how much trial prep did you do for that? And when I tell them maybe 10, 15 minutes, they're like, no, you did 10 or 15 minutes of trial prep for a criminal trial. And I'm like, when you get a rhythm with somebody that it just flows and where they want you to go, they just open a question up and the doors open and you walk through it.
Yep.
I try to find the jurors many that I can make eye contact with, and I think you notice that when you ask a question, I'll look at you, and then I'll swing the chair and I'll turn towards the jury, and I'll try to find 3 or 4 jurors that I can connect with and get them shaking their head or kind of wow, really? Is that what that means? And the same thing when the prosecutor did that. I don't answer the prosecutor back. I answer the jury because that's ultimately who's making the determination. But the Kusa case was a tremendous victory. it's sad to think about Dr. Bothra, Dr. Pompey, Dr. Sachi, not practicing because these are good doctors. They're
Yeah.
good human beings whose lives were completely destroyed by just nonsense. But I want to talk about the Reyes case for a moment because
Oh
even
yeah.
though it didn't make it to trial, that was still a fun case for me because I got to work with an attorney in your firm, Juan Santos.
Yep. Yep. Juan.
Um,
He's
he
our
was
Miami guy. Yeah.
he is. I love when he calls and he's like, "Hello, Sean. How are
Yep.
you? It's good to talk to you, man. What's
You
going
got to
on?"
go for a drink with Juan. He'll show you around Miami. He's a great guy.
Yeah, I can't. I'm gonna head down to Florida here in the next few weeks. I got to visit my 82-year-old mother, who's in
Oh,
Fort Lauderdale. So I'm gonna call Juan before I go.
yeah.
But can we just quickly talk about the Reyes case because there was some really bad stuff that
Oh,
happened in this case
this
with
is
the FBI agent, with the judge. I mean, just some bad stuff.
yeah, yeah. I think it was kind of crazy. First, let me say you say you did 15 minutes of trial prep. I want to work on that statement a little bit, Sean, because I think you've done
Okay.
about 30 years of trial prep. Okay. The,
Yeah.
the reason why you can get on the stand and do what you do, and the reason why I can trust that when I ask you a straightforward question, we don't need to prep answers, is because you know this stuff so incredibly well, and I think that's really where your prep has come from. So Reyes, um, this is fraud that went the other way, right? This doctor is an
Yeah.
emergency room physician, wonderful man, working down in Puerto Rico. Now, we've talked a lot about how small town offices can't bring these healthcare fraud cases because they just don't know the facts and they don't know the law and they don't know how to investigate it. That's what happened in Puerto Rico. They should have brought the Department of Justice in because at least they would have known it a little bit better. But he engages in a contract for emergency services with a company. He's paid a certain amount. I don't want to disclose that here for the services, but a fair market, reasonable amount of money. That would be for a medical director type position, not for his services that he was doing in the ER, just a little flat fee for his medical director services. So then he goes and sees patients and he happily bills for them just like any ER physician would do, gets reimbursement for them. Unbeknownst to him, the hospital, the emergency services group, is billing for the exact same services. The government recognizes it. They come after the individual providers, all of them. They say this is fraud. They only prosecute one of them, Dr. Reyes. Dr. Reyes picks up the phone and calls us. We look through it and we very quickly realize that there was no assignment of benefits, which you highlighted as well, which for your people out there, an assignment is required when a provider is authorizing somebody else to bill for their services. If there's no assignment, there is no contractual relationship that exists with respect to assignment, and the provider is the only person entitled to bill for their specific services without an assignment.
That's right.
This is required, right? So there was some issue as to whether that part of Medicare required an assignment. I think that's all nonsense. We do things in writing in the healthcare industry. There was no assignment. We brought that up. We were about to put you on as an expert. The government objected to you testifying because they said you're testifying to a legal issue, not a factual issue. And I said, no, this is a regulatory compliance issue. We lost that motion. Sean doesn't get to go down to Puerto Rico. I feel bad for you on that and for the client that they don't have the benefit of your expertise there. So we're like, fine, let's just have a good old fashioned trial. And I can see how well the government knows assignment of claims and benefits during trial. And we're ready. It's going to be a week. It's down in Puerto Rico. This should be a pretty easy one to get over. Get a call from the government literally days before trial. Hey, we want to work this out. Right. And you know what this means, Sean? Hi, I didn't look over the case pre-trial. I'm looking over it now and interviewing my witnesses, and I'm realizing I don't have a case. And so let's work it out. And so in the end, the healthcare fraud charges were dismissed against Dr. Reyes. He didn't have to see the inside of a courtroom for that case. And that was another big victory. And I would say, even though you didn't get on the stand for that, your help was vital because, we're sitting here thinking, are we crazy? There should have been an assignment. And you're saying, no, Ron, no, Juan, you're not crazy. There should have been an assignment. And I'll be happy to get on the witness stand and tell that to the jury as well.
Well, I mean, the judge refused all witnesses in this case.
Essentially, yeah. 2.
Yeah, I mean,
Yeah.
she said I think it was a female judge down in Puerto Rico, where
Yep.
she said, "I'm the judge and the jury, and I will make the determination. I don't need any witnesses." It was the most insane thing I've ever heard. It
Well,
was
she was
and
gonna allow fact witnesses, but with respect to the assignment of claims issue, she
yeah,
wasn't entertaining any witnesses, and listen, I have respect for federal judges and how difficult their job is. I do believe that
absolutely.
that decision was incorrect because I believe that issues of a regulatory nature are not issues of a legal nature, right? Regulations are complex, and they need to be viewed by experts, and that's where I think that they got that incorrect, but hey, we prevailed, so I'll take it.
It was an awesome it's been an awesome 12 months. The year is not done. I know we have more on the dockets,
Yep.
and, I have several, I have 5 more criminal cases on the docket this year with, different attorneys. I know.
Yeah.
Um, I pray that they, go in the same direction that the ones, the prior 5 that we've done together over the last 12 months go. I know you always have a million and one things going on, and, you are now a, staple on Fox News and on BBC, and, it's really neat to watch how your career, even after you had a career as a JAG,
Mhm.
attorney, now in the defense world, to really watch how your career has just flourished, and, and it's because of the hard work that you put into it. I think it's also important, that you recognize yourself, that people like Matthew Pelkowitz, who's an attorney in your firm, how vital he is and how good he is. He's one of the most good-natured,
Oh, yeah.
kind people. He is so unassuming, but he is so intelligent.
Oh, yeah.
Um, we had another great win, right?
Yeah.
I don't know if I can mention that one, but, it's in the northeastern part where, that thing has wound down, that criminal
Oh,
investigation.
yeah. I guess we won't mention the provider's name because they ultimately weren't indicted, and so nothing is published about
Yes.
that, which is fantastic. But yeah,
Yeah.
we have a doc who is facing a massive investigation where Sean, you brought us into that, and we were able to take care of it. Listen, I get to be on the podcast, I get to be on the news, I get to do all this stuff. I'm very privileged that I'm at a place, but all of this happens because there's a team. Stephanie Angelo sitting right outside my office, gatekeeping on
Yep.
all the stuff that comes in. Matthew Pelkowitz is on his 4th Supreme Court brief right now. If anybody out there reads anything that I've filed before the United States Supreme Court, chances are the ink is from Matthew Pelkowitz. I don't want to give that secret away. I'm on top of issue development and drafting, but in reality, he in his early part of his career has proven to be just an absolute sword fighter with words. I mean,
He
tremendous
is.
stuff. Such a great team. My hope now, and where I'm going with my career, is I want each and every one of these people to be recognized for their abilities and to be built up into a position like I am. This comes
Yep.
from having respect for the people that you work with and recognizing their talent, having fantastic relationships and mutual respect with people like you. Being kind to each other, as you say at the close of every single podcast. And then when it's time to go do business, do very serious business and do it very well. And that's what we try to do
Yep.
here at the Chapman Law Group and Chapman Consulting Group.
Absolutely, and I wanna give a quick shout out to Matt Lawhon, who
Yeah.
in that indictment, that pending indictment,
Mm.
um, he just did a phenomenal job dealing with the prosecutor on that case.
Yep.
He and myself were in constant communication. We really were able to hone in on, the fatal flaws that the government's case, raised.
Yep.
We were able to prevent the grand jury subpoena, and it has turned out very well for this client in the Northeast. So that's another win right there, man, that we didn't even think about. So
The battle
as
was won
always,
without firing a
it
shot.
was,
I'll take it. Yeah.
it was.
Yeah.
And one of these days, you and I are going to sit down over a couple of drinks, and we're just going to enjoy it. And but until then, we're gonna keep pounding away at this stuff. So, counselor, as always, thank you so much for carving out time from your busy schedule, and it truly is a busy schedule. And your friendship means the world to me. I know these other attorneys that are out there that listen to this podcast, both prosecutors and defense counsel. I know they're wondering how to pick your brain. I'm getting more and more calls myself personally from different attorneys that are like, "Hey, can you engage and help us in these cases?"
Yeah.
And listen, I tell people all the time, if there's a defense to be created, and as long as we know that this is not a bad actor, we'll engage and we'll do everything we can to help you, create a strategic defense to, acquit your client or to keep it from going to trial.
Yep.
So we'll continue to fight the good fight. So to each and every single one of you tuning in, logging on, and just hanging out with Ron Chapman and myself for the last 50 minutes, we greatly appreciate your time. Um, Later this week, I'll be back with another daily dose, and I believe we'll be back with Legal with Lyles Parker on Thursday of this week. Ashley Morgan, Robert Lyles, as I refer to them as the Wonder Twins, they're always fantastic on the program. Ron, again, thank you so much for being here, my friend.
Thank you, Sean. Pleasure to see you and to talk to you. Thank you so much.
All right. And to each of you, don't forget, be good to yourself, but more importantly, y'all be good to each other.